Good morning. Welcome into ClearPath Retirement Radio. As always, I am Stewart Smith here with Mitch Davies.
Good morning.
And we are here today to talk about trust and estate planning for retirees. How you doing today, Mitch?
Doing good, Stewart. I'm excited. This is going to be a good one. You know, this is something we've seen more and more. Trust estate planning has become more and more accessible over the years, and we've got a exciting solution to this thing, and I'm excited to get into this today.
Well, you know, I tell you, what I've noticed over the years is estate planning, it tends to intimidate folks, and they tend to kind of shut down when you start talking about this subject. And what I've learned is it's really not as complicated as we make it.
It's not.
And so we're going to help today. We're going to help give you a little clarity on that, help you understand, you know, when's a trust needed, when is, you know, a will suffice, all of those things that people ask us and wonder about. We're going to try to answer today. And let me just start by saying that, you know, some people come into us and they say, you know, hey, I've got a will, so I'm good, right?
All the time.
And that's a very interesting question, because always my answer is, well, it just depends on what you're trying to accomplish. So, you know, if you have your assets, and let's talk about it for a second. If you have your assets, you have investment accounts, you have insurance policies, you have annuities, you have those sort of things, and you've named a beneficiary on those accounts, then, you know, those things are going to bypass probate as a true beneficiary designation. And so you really don't have to worry about those things unless you don't want all of those assets passing to the beneficiary all at one time.
Right.
And that is something that we hear more and more of nowadays, where people don't want that. You know, I had someone in the office the other day and they said, listen, I don't mind if two of my kids get the money all at once, but that third kid, heck no.
Right.
I tell you what, he will go through it like a drunken sailor. So I want to make sure that we stagger that and give him so much every year or every few years, and that can't be accomplished with a will.
It can't. And this is you know, people hear this kind of planning and hear this kind of, you know, idea and get, again, intimidated. You know, people think a trust fund, right? I remember hearing the term, you know, before I got into this business, I'd hear the term a trust fund and assume it was this huge, complex legal thing to set up. But, you know, we can accomplish that sort of planning for people at a super low cost, super easy. You know, it doesn't take very long. Mm-hmm. And it's something that's much more accessible than you might think to accomplish that level of planning. And we'll kind of get into that today, but it's been exciting.
Yeah. So, you know, back to the will, you know, listen, a will is fine for, you know, if you don't mind stuff being probated. And that stuff that we just mentioned, the bank accounts, if you've named a TOD or POD, and that's a transfer on death or paid on death on those type of accounts, then those will bypass probate as well. Again, all being dispersed at one time. So, you know, that's, if you're good with that, then the stuff you got to worry about, and the stuff that we talk about the most, is real property. And what I mean by real property is typically real estate, things that, you know, are going to get caught up in probate typically. And, you know, how do I handle that stuff? And a lot of times a couple will be sitting with us and they will say, hey, we've got our home titled Joints with Rights of Survivorship. And what that means here in South Carolina is that, you know, it's joint with rights of survivorship, meaning it's jointly owned by that couple. And if one of them passes away, all the ownership transfers automatically to the living spouse. And that's great. That's awesome. And so most people think that's as far as they need to go.
Right.
And they will, you know, say, you know, we're good, right? And I'll say, yeah, you're good until the second spouse passes away. And then what happens, right? Like, then what do you want to happen to the house? Do you want the kids that are going to inherit it, do you want them to have to go through probate? Because if you don't mind them going through probate, then yeah, I guess you're good.
Right.
But, you know, most people, they don't want to go through probate. And if you've ever gone through probate, and I ask this question a lot in workshops, it's not a party.
It's not.
Right? It's no fun. Probate is a hassle. It costs money. It takes time. It ties assets up. And so, you know, if you have a will, the will is the probate document. It is what gets probated. It is what the probate judge uses to determine how to distribute your assets. But it does not avoid probate, which, you know, a lot of folks, that is their sole intention, is I don't want this stuff to go through probate. You know, some reasons that we hear constantly on that is, first of all, probate costs money. And, you know, I gave a great example in a workshop that I did yesterday of, you know, listen, if you own $100,000 home, a home worth $100,000, the typical probate cost on a $100,000 home or a $100,000 estate, as we would say, is 3 to 7%. So at the lowest end of that, you're looking at probably about a $3,000 bill to probate that home, which, let's face it, a $100,000 home nowadays is not much, right? I mean, most homes average in the, you know, $300,000 to $400,000 range here. So, you know, I would say that, you know, to be able to avoid that, to be able to avoid not only that $3,000 fee, but also the hassle of going to probate and filing the paperwork and waiting for that to get in front of a judge to be, you know, finalized and dismissed, having creditors be able to come at you and say they owe you money, or, you know, putting that out into the public as public knowledge, which what probate is, and a lot of people don't understand that, you know, probate is public matter, and you leave assets to the next generation through the probate process, you're giving everybody access to that information. So a lot of people want to avoid this whole mess of, you know, having to go through the probate court, having to wait, having to be, you know, subject to creditors, having, you know, all of that be public knowledge. And, you know, for folks that come to us and want to just create a trust, and what we create typically, you know, 99% of the time for folks is something called a living revocable trust. Let me say that again, a living revocable trust. And what that does is it creates kind of a funnel, so to speak, for your assets. And anything that you fund that trust with, once it's established, anything that you retitle into that trust, which is a little bit of a step, but not really. I mean, it's not that difficult. A real estate attorney or title company can handle it. It's a few $100s typically to get your home retitled. But to get something retitled into that trust, now it funnels into the trust and is distributed according to whatever specifications you put in the trust, and bypasses probate completely. And it's a private matter, right? And creditors can't come after it. Predators can't come after it. The whole 9 yards, you know, where it's, you know, it's just so much easier. And we do those every day for our clients in our office, where they don't have to leave our office. It is a attorney-driven process, because we've partnered with several local attorneys in South and North Carolina that have partnered with us on this, and we are able to bring them into the fold virtually and build out the trust, do everything, notarize it, witness it, make sure the language is bulletproof, make sure it accomplishes everything you need to accomplish. And we do that. If you have no other business with us, you can come in and do that for $1,400.
Yep.
So, you know, that is $1,400 up front to avoid the hassle, the time, the public, you know, display of what's going on, all of that on, you know, what would cost you maybe $3,000, $4,000, $6,000, $8,000 to get through probate. So it just, at this day and age, it doesn't make sense for you to go let your assets go through probate when we can do a living revocable trust for you so easily, so conveniently, and at such a fair price that, you know, it doesn't make sense to have this stuff in a will anymore.
There's no reason not to. I mean, the couple steps it's going to take us to establish the trust and get things titled in the trust and get everything into that funnel. If you've never dealt with, you know, probate and a probate judge and a probate court, there's 10 steps. I mean, you're going back to that court multiple times. We see it all the time, right? You have to go back, and then you have to get the attorney, you have to get the letters testamentary. Maybe people don't know how to do this. It's complicated. There's a lot of different steps. So we take a couple hours to get this trust established, get everything titled in it, and your life and the next generation's life is infinitely easier.
If this is something that appeals to you and you've thought about it, but you're just not sure how to take that next step, come to ClearPathRetirement.com. Let us know that this is in your thoughts, and let's set up a time to sit down and talk. We'll be right back to talk a lot more about this.
Nice.
Now,
So it's easy.
hey guys, we're back. It's ClearPath Retirement Radio, and today we're talking about trust and wills and estate planning and all of that stuff. And we're having a good time with this, Mitch. Just to reiterate here, we're talking about living revocable trust and how easy and convenient it is to set one of those up nowadays, and how it can just be such a powerful tool to make sure you leave those assets to the next generation in the most tax efficient, the easiest, smoothest possible transition to move those assets with, bypassing probate and all of the hassles that come along with that, and all of the cost and the time consuming process that is probate. And, like I said in the last segment, I just don't understand why anybody would just stop at a will nowadays and not go ahead and take just one more little step and create that living revocable trust. Like I say, cost you $1,400 with our office and our firm to do that. You could be avoiding potentially on the back end, 2, 3, 4 times that in probate costs and hassle and, paperwork and all of the other things that just don't make sense anymore. And so, we haven't done a will in a long time because trusts are just too cost effective, and they just do so much more than what a will can do. And so, we definitely are big believers in taking that next step. And, if you do work with us and, chances are you got a trust or you're in the process of getting a trust, and we are, the biggest question that we get is, okay, now we've established the trust, we have everything lined up, I know exactly who's getting my assets. We talk through it. We talk through everything you own, down to your jewelry, your gun collection, your coin collection, whatever it is that you have a significant value. We make sure that everything is going exactly where you want it to go. We get that trust established. We get all the language right. We get it into a beautiful leather binder tabbed out. We have an electronic copy for you. we notarize it, we witness it in the office, we make that an official document, and then people are like, what's next?
Right.
So here's the way it goes. And a lot of people get real confused on this and like, okay, now I have a trust. How do I fund the trust? In other words, how do I go about getting the assets that I need to be in this trust in the trust? And that is all about how things are titled. So, most people, the first step they're going to want to take is getting your home, your primary residence, and any other real estate, land, rental properties, vacation homes, whatever those things are, getting those things retitled into the name of the trust. And a lot of people think automatically, oh, that sounds like a lot, Stewart.
Yep.
No, it's really not, guys. You just get a good real estate attorney or a good title company, and just depending on where you're at, and you get that executed for probably less than $1,000.
Yeah,
As far as if it's multiple properties, probably in the neighborhood of $200 to $300 if it's just your primary residence. And I mean, it's a quick deed, guys.
Quick.
It's not that big of a deal, and don't be overwhelmed. Don't be intimidated by that. It's really not a big deal. And then people will always say to me, but Stewart, we might sell our home.
Go.
How does that work?
So, you got to understand, to make this make sense, let's understand the living revocable trust a little bit more. This is, people get scared of the, I'm going to sell, or the permanentness of this, right? With the big difference, and there's always a misconception here, with the living revocable trust, it's not its own tax entity yet. You still own it. It's still using your social security number. You still own it, and you can, hence the word revocable, you can make as many changes to it as you want. So a lot of people are like, oh, I don't want to put stuff into trust yet. I mean, I don't know what I'm going to do in the next 10 years, right? So when we create this living revocable trust, you still have complete ownership of the property, or whatever the asset that is titled in the trust is. You can still change it and do whatever you want. If you go to sell the house, it's as simple as selling it without the trust, as long as it's a revocable trust. Now, if we put things in irrevocable trust, which most people won't have, that's a different story. But what we're doing for 99% of people is that living revocable trust, where you still own it, your tax ID is still yours, the ownership, you can change anything, you can change beneficiaries, you can do whatever you want. But once you pass away, then it becomes irrevocable, and that's when the true power of the trust is. But while you're alive, you have full flexibility with that.
That's right. You have complete control of the trust. And, if you go to sell your home, basically what happens is the trust sells your home, but you own the trust. So it's that extra layer of protection between you and the actual ownership, which does protect you against other things as well, like predators and creditors. But the basically all that happens is on the documents that you would use to sell the home, you would just use the trust name in the place of your name. That's it. It's no big deal. And then if you go buy another piece of property or another home, then you would just have that titled into the trust when you do that. And all that takes, guys, is when you get a trust, there's one page of that trust called the Certification of Trust page. And on that page, it's got everything they need. And so you can just give them that one page from the trust document and say, I want this property titled in my trust, or I want this new home titled in my trust. It's no big deal. It doesn't cost you any more than if you titled it in your name. So it's that stuff is just simple. It's easy. There's no, like Mitch said, there's no separate tax return. There's no EIN for a trust. It's just your social security number. It's very simple, guys. We over complexify this situation. We get it all convoluted in our heads, and it's just not. It's a very simple deal, and it's very easy to do. And when you go, you can retitle your vehicles in the trust, which is nice because a lot of times vehicles get caught up in trust and people don't want that. They just want it to go to whoever they want it to go to very easily. And you can retitle just about anything that has a title or a deed or anything like that into the trust, and it just think of it like a funnel. You're just, once you title that into the trust, it funnels into the trust and then gets distributed according to the trust document and bypasses probate, which is huge.
Huge.
So, you know, today what we see, and it's just, you know, life is a lot more complex today. And what I mean by that is, you know, we see a lot of blended families.
Definitely.
And, you know, one of the things that, you know, we've been able to accomplish is to get real clarity on, you know, what those blended families, how they want things to go. Because I can tell you that if you were on your third marriage and you've got kids from the first two marriages, and you know, you both are have had multiple marriages with multiple kids, with multiple people, things get complicated really quick. And that makes for a real, you know, planning need to get clarity on, okay, well, if something were to happen to me, how does my estate get distributed? And you might have assets outside of your partner that are only in your name. You might have assets that are jointly held, and then your partner might have assets outside of the marriage that are only in their name. And that stuff gets complicated. And a lot of times, I was just sitting with a couple recently that was in this type of situation, and you know, they had very, very distinct visions of what, you know, they wanted to happen with their assets that were held in their name, as opposed to the assets that were held jointly with their current marriage. And so, you know, the only way to really get clear and to really make that a smooth transition is to have something like a living revocable trust that can really, where we can sit down and in a, you know, an hour and a half meeting, you can talk me through like, hey, I want this child to get this. I want this child to get this. You know, we just had a situation where one child owned a percentage of the parents' home, and they wanted to make sure that if something happened to them, that child got, you know, a distinct share of the home value prior to the rest of it being split up between the other siblings. I mean, these are complicated situations that can be addressed, and we do it every single day in our office. I mean, we've got situations where one spouse, you know, owns the home and the other spouse just lives there, and you know, they're not on the deed, and you know, that one spouse says to us, hey, if something happens to me, I want my spouse to be able to live in the home as long as they're alive, and then once they're gone, I want it split evenly between my natural children. And we can create that scenario inside of a trust and make sure that that's able to happen legally, and that you don't have to just rely on your kids telling you, yeah, we're gonna make that happen or let that happen, because the truth is life changes, people's feelings change, and the day that you know, a week after you're gone, they may have a change of heart and say, no, we want this old man out of here, and we want to sell this house and get our money now. You know, so you can protect against those sort of things. And listen, guys, if these thoughts are going through your head, if you're laying in bed at night and you're having these kind of thoughts about, oh my gosh, what would happen here, what would happen there, just you come to ClearPathRetirement.com. Give us a call, 864-775-5033. Let us know you want to sit down and just have a real conversation about these issues, and help us to alleviate that anxiety you're feeling by answering these questions. Guys, we'll be right back. And we're back here at ClearPath Retirement Radio. I am Stewart Smith, here as always with Mitch Davies, and today we're talking about living revocable trust. But before we get back into that, I want to just throw it over to Mitch for a few minutes here for our favorite segment of the show, and that is Mitch's Market Minute.
Thank you, Stewart. Yeah, I'm excited as always. Like Stewart said, we'll switch gears for just a minute here and just talk about what's been going on. This is a great time to talk about this because there's been a lot happening in the markets, and we've seen a crazy couple weeks play out. And this is something we've been talking about for 2-3 months now, is almost expecting this exact scenario. We did a segment a few months ago, or a few weeks ago, sorry, talking about the history of these types of events, right? And what happens almost every time. What happens almost every single time we have some kind of geopolitical tension is that we see a sharp dip and a sharp recovery. And today, the market is almost at all-time highs again, and we've seen 5 days in a row of extreme green days. And this is so important to have a team, whether you're retired, getting ready to retire, who understands this stuff and is able to talk you through this. Because we had so many clients, we do a lot of client outreach. We do, especially during times like this. This is the time where you hear from us the most, is times like this where the markets are super volatile. We were talking to so many different people about, hey, look, here's the history of what happens in these things. This isn't the first time we've seen this. So what generally happens is we have a 4 or 5 week stretch of red days where we're slowly coming down. S&P was about 10% down from the, all-time high. And just in a span of 5 days, we're back to that. The S&P hit over $7,000 today. So what we see is that sharp recovery. And it's so important to understand the way the markets react in these things. We have 120 years now of market history to study and to understand that there's been geopolitical tensions before. There's been wars, world wars before. There's been pandemics before. There's been everything that could happen we've seen before, right? So there's nothing new here. So what we're seeing today is what we've been expecting. The S&P almost at all-time highs, NASDAQ almost at all-time highs. Oil is starting to drop. Oil, we've talked about this, has been the driver behind this. We've seen the Strait of Hormuz, which is just south of Iran. They have control over it essentially, and they blocked that off. And we've seen oil not be able to flow through there. And this strait controls 20% of the world's oil supply. The US doesn't use much of it, but everybody else does. So that affects the overall oil price, right? And we've seen we're starting to see some de-escalation talks. We're starting to see that the strait is partially open and they're going to toll it. We're starting to see these different reports, but the second these start to come through, the market just flies up because the market's ready. When we have volatility like this and we see a huge green day just because of one report, that means the market's ready to go. The market's ready to run. It just needs a little bit of fuel, right? And oil coming down and the volatility index coming down and the market's pushing all-time highs is that fuel. It's ready to run. So the most important thing you can do in retirement, whether you're doing this yourself or you're working with somebody, is make sure you have a team that understands the market history and psychology behind this. Because what we do differently we're only working with retirees. What we do is we have our clients allocated ahead of time not to suffer huge drawdowns, because it's hard. When you're in retirement and this is all the money you've got and you've got to invest it and you're fully exposed to the market and you see that 10, 15% red in your account, even if you understand, even if you have us saying, hey, look, it's gonna come back. That's what everyone says, right? But it's hard to see that. And it's hard to sit there through that. And that's when you make bad decisions. That's when you sell. But what we do is allocate in a whole different way where we have a large portion protected or semi-protected where they're only down 3 or 4% instead of 15. And they're able to sleep and understand so much better that no matter what's going on in this time, we understand the history. I've got a team behind me that's able to work me through this, and I'm not even down the full 15%. So the most important takeaway here, guys, is that any event that's happened has already happened in some form of the way, as far as the market's concerned. Whether it's tension in the Middle East, we've seen that how many times over the last 50 years, right? We've been dealing with that for 40 years. So we've seen these types of things, and we have history. We have so much data to understand what happens, and the market's right on the edge there. So if you've been stressed the last 6 weeks, what I'll challenge you, if you've been stressed the last 6 weeks and you don't have a direction, you don't have a guidance, you don't have anything like this, and you're in retirement especially, if you're just beginning investing and you're contributing, maybe it's not as much a big deal. But if you're in retirement and this is the money that you've got to live on, and you've been stressed these last 6 weeks dealing with the uncertainty and the scary news headlines and all this, give us a call. Just come in and talk to us. Let us sit down, understand where you're at, understand where you're trying to go, and see if there's a way we can help you. See if there's a way we can, help you through that and coach you through this process, because it's hard alone, especially in retirement. And this is what we do every single day for people. So take a look at that for me.
Great segment, Mitch. We really help folks smooth out that ride. When it gets extremely volatile like this, we see people that they get really, nervous. They get panicky, and they start wanting to, and what we're able to do is, you know, give them a call, talk to them directly, let them know, you know, what our thoughts are, calm them down, you know, make sure that you know, we are reallocating as we need to, make sure we're reacting correctly to what the markets are doing. And, you know, a lot of times that means staying put. And, you know, we understand that. And a lot of times, you know, that can pay huge dividends by not making any drastic changes. But, you know, if that, like Mitch said, if it's too volatile for you, it's got you, you know, anxiety ridden and not sleeping at night, give us a call. Let us smooth that ride out for you. Let us get you to a better place. And we, you know, we would certainly appreciate the opportunity to do that. Okay, so great segment. Let's get back to talking about the topic of the day, which is living revocable trust and what a powerful tool they can be in estate planning. And, you know, like we said earlier, Mitch, you know, people hear the word trust and they get weird about it,
Yeah.
don't they? They get like, oh, this sounds so complicated and I just don't know.
Yep.
But we're here to tell you guys, it's really not complicated. And if you've ever been through probate with a family member, you probably, you know, it's a lot more complicated than doing a living revocable trust. And you know, a living revocable trust will help you to avoid probate on all of your assets, help pass those on to the next generation with no muss, no fuss. It's going to really, really make, you know, your beneficiaries' lives so much easier. It's going to keep those, you know, those transferences private. It's going to keep all of that private, which a lot of people really appreciate. You know, years ago, I had a client pass away and leave a very, very significant amount of, you know, assets into one of his children. He only had one child, and, you know, that child shared with me a few years later, because he did it through a will, and that was public knowledge. He shared with me years later that he was just hounded by phone calls of people, you know, pitching him different investment ideas, and complete strangers, you know, coming after him, understanding that he just inherited a significant sum of money. So you don't want to do that. You don't want to leave your assets in a manner that is public knowledge where that kind of thing can happen. So let's talk about, you know, just some practical estate planning tips that I think make a lot of sense for people. One is get that living revocable trust done. Like we said in earlier segments, we'll do the entire process with you, attorney-driven process. We will also include, you know, healthcare and financial power of attorney in that, which are both extremely important documents to have in place in case, God forbid, you become incapacitated. You know, my personal story, I can share that, you know, my father, who, you know, suffered a major fall when he was in his late 30s and had health issues the rest of his life because of that. You know, at age 70, you know, I remember sitting with him and pressing him like, Dad, you're not remembering things, you're not making great decisions anymore. I really want you to sign these power of attorney documents so I can make sure that if and when the time comes, that you are taken care of. And he said, you know, son, I will sign these documents because I believe in you and I trust you, but you're never going to need these documents. And it was not 6 months after he signed those documents, he suffered a stroke and was in a memory care unit for the rest of his life, which was 6 years. And, you know, thank God that I got those documents signed and that I was able to sell his home and all of his assets and, you know, make sure that he received the best possible care he could get for those last 6 years. And, you know, had I not done that, had a little voice not spoken to me and told me to do that, then I just can't imagine the nightmare that I would have been caught up in trying to get all of that done for him. So this is, something that needs to happen, and, just quit quit procrastinating on this, get real with it, and, get with us, get with another professional, someone who can handle this for you, and get that living revocable trust done, and then take the proper steps to get it funded correctly, meaning get things retitled as needed to go into the trust and be part of that trust. And if you are confused about how to do that, and you're just not sure, you think it makes sense, and you think that avoiding probate makes sense, and avoiding all the cost and the pain that comes along with probate makes a lot of sense, but you're not really sure where to start, just give us a call, 864-775-5033. We'd love to have that conversation with you, and we can sit down and really, really get our arms around, what it is you're trying to achieve, and we can make sure that all of that is taken care of, and that, you can sleep better at night knowing that these things are going to happen, and they're not going to, it's not going to be a nightmare for your beneficiaries there.
And guys, the healthcare piece is such an easy place to start. The healthcare directives do not take long. And there's, a big misconception there, Stewart, is I was, sitting with a client the other day doing a healthcare power of attorney, and he said, well, I'm good right now. I don't want to relinquish my ability to make decisions now. And it doesn't take effect until you need it to, right? You're not signing away your power to make a decision today. So there's almost no reason not to have that in place. We can take care of that for you in 30 minutes, And in Stewart's example there, it was a life-changing decision to go ahead and sign that document. Yeah. And this stuff is changeable. You could change that later down the road as long as you're still, mentally capable. So there's no reason not to have that. Let us take care of that for you. It's so easy, it's so fast to do now, and it can truly be a life-changing decision to go ahead and set that up, because in the blink of an eye, that can change.
It can. Guys, if you're thinking all this makes sense, again, if you're thinking this is, something that could be the right tool for you, give us a call, 864-775-5033, or go to our website, ClearPathRetirement.com. Let us know you want to chat. Let us know you want to have a conversation about this stuff, and let's get you headed in the right direction today. We'll be right back. Hey, we're back with ClearPath Retirement Radio, and today Mitch and I are talking about living revocable trust and whether they make sense for your situation and your estate planning. And, I would say that, Mitch, I think it's just a no-brainer.
It's a no-brainer, Stewart. And, we've been talking about misconceptions, and there's a lot of them, especially surrounding real estate. One of the main ones that I hear, we talked about, just to recap, we talked about at the beginning how the revocable living trust it's still in your Social Security number. It's still in your tax ID. You're not removing this asset from your estate. So one of the main misconceptions I hear is, hey, if I put my house, my primary residence, whatever it is, in a revocable living trust, I'm going to lose the step up in cost basis. We hear this all the time. And this is not the case. People will say, well, my grandma or my mom had a house and she put it in a trust and we didn't get the step up. So a lot of people used to do these irrevocable trusts. This is when you remove it from your estate, because the estate exemption used to be lower. But now with the estate exemption at $15 million essentially per person, at $30 million for a married couple, we're mostly just doing these revocable living trusts. And when you put your house in the revocable living trust, you don't lose the ability to step up the cost basis. So what that means is if you bought your house for $50,000 and you pass away and it's worth $800,000, the beneficiary is going to get a step up in cost basis. So they don't own it at that $50,000, so they can turn around and sell it right away and not owe taxes. But this remains true in a revocable living trust. You still own it. It's your tax ID. It's your Social Security. You still own the house. It becomes irrevocable once you pass. So you still are able to enjoy the benefit of a step up in cost basis, which is extremely important in retirement planning, is to be able to have that, because real estate is appreciated so much. So one of the big misconceptions we hear is that, oh, if I put the house in the trust, I'm losing the step-up in cost basis. You're not. This is a revocable living trust. You don't lose the ability to enjoy that huge tax benefit that we get. And you'll still maintain full flexibility, but again, it's going to put it in that funnel. So instead of dealing with different probate courts and different beneficiary documents, let's funnel everything into one bucket. Let's retitle assets in the trust. Let's make the trust the beneficiary of investment accounts. It'll take 10, 15 minutes. Let's even, with after-tax accounts like investment accounts, brokerage accounts, if you have large brokerage accounts that you've just set up with after-tax money that you're holding stocks in, we can retitle those in the trust. That's even easier. You don't even need a trust. You don't even need a title company. You can just do that with Fidelity or Schwab or whatever the custodian is. Let's do all that. Let's take 20 minutes per account and set that up and save the next generation from hours and hours and hours of probate court trips and driving down there and phone calls with attorneys and staying on top of them and trying to wait for a follow-up. I mean, as you can imagine, Stewart, the probate court is the most efficient process we have in the world. So let's spend the time now to set that up to avoid the headache down the road.
Yeah, and we get asked that a lot, like, what do I want to put in the trust? What don't I want to put in the trust? I would say one rule of thumb is you don't want to put pre-tax accounts in the trust, like IRAs and 401ks and that sort of thing, because those accounts are going to require minimum distributions at some point, and you want to keep those in your name so that the RMDs, the required minimum distributions, can be done correctly without confusion. But one thing that we do is we will make the trust the beneficiary of those type accounts, so that when you do pass, the money goes into the trust and is distributed through the trust. For, like Mitch said, for brokerage accounts, those can be titled actually directly into the trust, as well as bank accounts and things of that nature, so that they are just automatically passed through, through the trust according to your wishes. A lot of people will say, well, what if I've added, gone ahead and added one of my children to the bank account? I mean, that can work too, but I think it's better and cleaner to do it through the trust for sure.
Right.
Because we have seen hiccups with that sort of process of just adding them to the account. You are giving them access to that account prior to your death, and that can cause some problems, and it can cause problems after death where, we've got an issue going on right now where someone was on their bank account and a relative, but they're having all kinds of issues accessing those funds right now and having to jump through a bunch of hoops to get to those funds. So not necessarily the best thing. And then, another question we get all the time, Mitch, is what if I have a mortgage? What if I have a mortgage on my primary residence? Can I put it in a trust? Yes, you can. Most, we've never had an issue, as long as it was your primary residence and it's a living revocable trust, putting that into the trust while you still have a mortgage on it. That is not a problem. Where it can be a little more difficult is if you are putting, rental properties, you're putting land and things of that nature outside of your primary residence in the trust with a mortgage on it.
Okay.
And in that case, we just always recommend that you contact the mortgage company, and that you have a conversation with them to make sure that they're not going to try to call the loan or something if they see some change in ownership from you to your trust, which, we've never had that issue either, but it's just double check and make sure. We don't want any weird, stuff to come up. So you just want to kind of double check with them and make sure, like, hey, you guys okay with this? And usually it's never been a problem for them. They don't mind. They understand it's a living revocable trust. You still control it. You're still responsible for all the payments, and that it just isn't a problem. So if those things are holding you back, don't let those things hold you back either. Those things can easily be addressed, and we can help you certainly if you have questions on that. So, here's what I would say. Do the healthcare power of attorney, do the financial power of attorney. Just God forbid, in case you become incapacitated. And when I say that, I don't mean unconscious. I mean, you can and will get to a point in your life where you just can't make the best decisions anymore. And trust me on this, you'd rather name the people ahead of time that you want making those type of decisions, and you completely control that process, than have the state figure it out after the fact. And so it's extremely important that you get those things in place. And like Mitch said, literally takes us 15, 20 minutes to get those done. As long as you know who you want handling that, we can knock that out really quickly for you. The other things I would say is, if you're relying on beneficiary designations on your insurance products or on your, investment accounts and those sort of things, if you are relying on beneficiary designations to bypass probate, make sure those are up to date. We have seen, I can't tell you, I had a client that was an extremely successful CEO of a major engineering firm, had just gotten remarried, had a $1.2 million life insurance policy on, himself that he had forgotten to change the beneficiary from his ex-wife to his new wife, and unfortunately was involved in a car accident on the way home from work one evening and did not make it. And the ex-wife got $1.2 million tax-free. And, just because he had forgotten to change his beneficiary, and the new wife actually sued for over 3 years trying to, legitimately get a portion of that money, and was not successful. And so, those things are critical. If you haven't visited that in quite a while, then I suggest you do what we call a beneficiary review. And you're welcome to give us a call and come in. We'd be happy to sit with you and go through those things and make sure that everything gets updated to your liking. Your estate plan, you've got to review your estate plan every 3 to 5 years, even if you just have a will. And a lot of people ask me why. I mean, I did my will 17 years ago. Is it not still good? Well, it could be, but, if you're in a situation where you feel like there is any reason for someone to challenge that will, and even if that means you have 2 or 3 children and they don't necessarily get along, and they may not agree to exactly the way that you have your assets being distributed in that will, and one of them doesn't think it's fair, they can certainly go hire an attorney and challenge the will. And I'm here to tell you, if that will is 17 years old and has not been revisited in that time frame, guess what's going to probably happen? Yeah. That probate judge is probably going to throw that thing out real quick, and they're going to decide how to distribute your assets from there. So what we recommend is every 3 to 5 years, even if you just have a will, sit down, review the will, make sure it still, it speaks to your wishes, and then re-sign, re-notarize, re-witness, whatever it is you need to do, and make sure that's done every 3 to 5 years, because that way, if someone challenges it and it's been done in the last, 3 to 5 years, then it's probably going to hold up. So that's a big deal, and then again, when it comes to estate planning, think beyond just assets. Your land, your house, your cars, your bank accounts, all of those things are ripe for, probate. And if you don't have those things set up correctly, if you haven't taken the extra step to go name a transfer on death or paid on death on those bank accounts, and you don't want to do the trust and retitle them in the trust, take that extra time, take that extra step. It's going to save someone a lot of hassle, and it's really not that difficult to do. And I have noticed that banks, when they set up, bank accounts, a lot of times they're not going to prompt you for that. That's something you have to go and ask for. So make sure you're doing that. So I hope everybody's benefited today. This has been a great show. If these are all concerns of yours, if it's got you thinking, if it's got you concerned, and you're not sure if this stuff's right for you, again, visit us at clearpathretirement.com and let's have a conversation and just see if this is right for you, see if a will works or a trust is better. And until next week, happy retirement, everyone.